You're live. Good morning. It is January 29th in Senate Judiciary. Renee McGinnis from the Vermont Family Alliance.
Yes.
And yeah, the floor is yours if you wanted to hear your views and your thoughts on cross border.
Sure. Thank you. Thank you for taking my testimony today. My name is Renee McGinnis. I'm the policy analyst for Vermont Family Alliance. Vermont Family Alliance is a parental rights and minor protections advocacy group. Vermont Family Alliance acknowledges that there have been many violations of equal rights in the past and is not opposed to an equal rights amendment with broader language as recommended by Peter Teachout, constitutional law professor, and only if it is equally applied. Our main concern after analyzing Prop 4 testimony by constitutional law professor Peter Teachout and listening to discussions on Prop 4 in both the Senate and House Judiciary committees in 2024 is that the legislature will pass laws that discriminate against biological women, Christians, and traditional families by providing expanded protections to some of the finite list of persons, state-sanctioned historical marginalized populations under Section 1, Purpose B, and specifically under gender identity and gender expression in the proposed amendment. Vermont Family Alliance is opposed to the passage of Proposition 4 by the General Assembly to put before the voters in November 2026 for the following reasons. Number one, Prop 4 presents a finite list of groups that are protected by laws passed under Prop 4 at the exclusion of other groups. Peter Teachout pointed out that the finite list of protected classes presents an interpretive challenges for the courts in his testimony to this committee on January 30th, 2024. He recommended broader language along the lines of the 14th Amendment of the U.S. Constitution as follows: every person is entitled to be treated with equal respect and dignity under the law. Therefore, government acting either alone or in conjunction with private actors shall not deprive any person of life, liberty, or property without due process of law or deny any person the equal protection of the laws. The legislature shall have the power to enforce the provisions of this article with appropriate legislation. The Senate Judiciary did not take up Teachout's suggestion for broader language and passed Prop 4 out of committee with a finite list of groups. Teachout also stated in his testimony to the House Judiciary Committee on May 1st, quote, once you start listing protected classes, you raise the question of why the particular types of discrimination are listed and others are not. The law has a technical term for this reflected in the Latin maxim, expressio unius est exclusio alterius, which means that if you include certain classes in a closed list, you mean to exclude others. Because of the way Prop 4 is currently framed, practitioners and courts will constantly be faced with difficult questions. Are members of the classes specifically listed in the amendment in Prop 4 the only ones entitled to judicial protection against discrimination? If not, are they entitled to special protections that members of other classes are not entitled to? If neither of those, then what is gained by listing them? Teachout suggested that, if possible, the House Judiciary Committee return Prop 4 to the Senate to request a quick fix by inserting language on the grounds such as to expand protections to all groups of people. He wrote, it is important to remember we are considering the adoption of a constitutional amendment, a fundamental statement of governance that is supposed to guide us over the long term. So while we are doing it, it's important to try to get it right. The House Judiciary Committee passed Prop 4 out of committee, knowing that the language would cause issues with interpretation in the courts, because passing Prop 4 within the 2024 timeline was a higher priority than getting the language right. Legislation passed under Proposition 4 that intentionally or consequentially prioritizes the rights and protections of transgender women over biological women will face court challenges. He stated in his January 2024 testimony to Senate Judiciary that, quote, the federal standard establishes the floor below which states cannot go, but it does not prevent states from providing greater protections. The limit is when the state law conflicts with federal constitutional law. That is the limitation that Vermont would face if it were to attempt to invoke a newly added equal protection clause as support for adopting affirmative action programs, giving preferences to members of historically disadvantaged groups. He brings up the U.S. Supreme Court case, Students for Fair Admissions versus Harvard, North Carolina, and skipping down to the next highlighted section. So if the state constitution were to be amended to include an equal protection clause, that clause could not be invoked by the state as support for adoption of affirmative action programs that take this form. Since federal law is supreme, all such programs would be vulnerable to challenge under the federal equal protection clause on grounds they constitute impermissible discrimination on the basis of race, end quote. Vermont Family Alliance further asserts that any laws that elevate the rights of biological males that identify as females under gender identity and gender expression under Prop 4 will be challenged as a violation of the Equal Protection Clause in the 14th Amendment. Number 3, legislators have already demonstrated, some legislators have already demonstrated that they have a mindset to discriminate against some groups under Proposition 4. The original 2019 proposed amendment contained religion. It was removed in the 2023 version, and then it was added back in this committee in 2024, which suggests the likelihood that some legislators will not exercise equal protections in laws introduced and passed under Proposition 4, but will actively attempt to discriminate against some groups by expanding protections for some of the finite list of groups at the expense of others. Number 4, any laws passed under Proposition 4 that expand protections for gender identity and gender expression over biological sex will be challenged as unconstitutional. We already see this. Any Vermont laws passed under Prop 4 that bump up against the Equal Protection Clause of the 14th Amendment of the U.S. Constitution and SCOTUS decisions, such as Students for Fair Admissions versus Harvard, will face a legal challenge. B, Mid-Vermont Christian versus Saunders, given the preliminary injunction to allow Mid-Vermont Christian back into the Vermont Principals Association. We anticipate a decision in favor of Mid-Vermont Christian regarding their participation in interscholastic sports and town tuition. The Supreme Court decision coming in early summer 2026 on whether to uphold state bans on transgender males and girls' sports under Title IX will also serve as precedent, and we anticipate a decision in favor of upholding state bans, which will apply to states that allow transgender women to play girls' sports. Number 5, legislators have failed to disseminate information to the public on Proposition 4. There were fewer in attendance at the May 1st, 2024 public hearing than there were members on the House Judiciary Committee that hosted that public hearing. Only 6 people, none of whom were from the general public, testified. And number 6, quite simply, Proposition 4 will give the Vermont legislature neither the constitutional upper hand nor the moral upper hand that it is seeking. The Vermont legislature simply cannot pass laws that expand protections for a finite list of Vermonters while violating the rights of other groups due to the supremacy clause of the U.S. Constitution and SCOTUS decisions. That's my testimony.
Yeah. Committee, any questions?
No, I do have a question. My understanding that we can't change it from what it doesn't want to be done.
Correct. Yeah, not the same thing.
And the house could never change things, right? It was always.
Right.
Pattern.
Yeah, thank you. I suspect that we could spend a lot of time talking about all the different points and debating that. The only question that I do have, more of a procedural question. It is important to me to make sure that everybody has access and information to what is going on here, regardless of their viewpoints. So I guess with number 5, regarding failure to disseminate information to the public, are there specific things that you believe we haven't shared, or do you think that we need to have more public hearings, or what? Trying to get a better idea on what.
Yeah, I think the poor attendance might suggest that people were not aware or not aware of this constitutional amendment. And then I don't know whether or not, I know my legislators are not sharing this in their newsletters. I'm not receiving any information from my representatives or senators about this constitutional amendment. And I think we need an educated citizenry to understand what they're actually voting on. The purpose section is relevant. I think it's very important. They will just be looking at the language of what would appear in the Constitution. And I think people deserve more information before they vote on that. And
Thank you. I agree with that.
I also just have a procedural question. It's been a while since we've done this, research the time lock. Do we have to have this public hearing in the second biennium? Because I know with the two last constitutional cycle, we had one to vote, but
That I don't know.
if I may, I believe so, because the House chair of Judiciary, Lamont, I think he did mention court turnout at the first hearing, that he said that he had another go around. So actually, I take that back. I'm not sure if he's actually said he's going to be here. He just knows that it's going through this process again. Hopefully more people come to know about this, but I think there needs to be an active, proactive means to do that to get this out to the public.
so that's my first procedural question, and my other procedural question, and it may be a better question than Secretary of State. I'm happy to follow up, but they have to publish information once this goes to the ballot for the citizens to vote on, right?
I believe so.
Okay, that's what I thought.
Yeah, it would be that. Eric, if you make a note about a public hearing, we have to figure out. We'll figure it out, but just note for the future, please. Thank you.
So I thought there were pretty specific layouts about how we had to share it, who we had to share it with, who the Secretary of State had to share it with. I thought that was pretty well laid out in statute, so I just like to brush up on that.
Yeah. Any other questions? Great,
Thank
thank
you.
you. And we'll stay.
You too.
We are now switching gears here from Jack from about legal aid. See you, Jack. And just a note for viewers, we did have a change in the agenda. There were several folks were going to have to find together. I believe the main presenter was unable to be here, so they asked to move their testimony sometime next week. So we've got plenty of time for it, and we'll hear from additional witnesses moving into next week. Yeah, floor is yours.
Thank you, Mr. I'm Jack McCullough. I'm a lawyer from Legal Aid since 1952, and I'm the director of the Mental Health Law Project. And in the Mental Health Law Project, we have a contract with the state to represent everybody in the state who's subject to any type of involuntary mental health proceedings. That includes people whose condition is sought to psychiatric hospitals, people who are admitted and there's a request that they be involuntarily medicated, people who are living in the community on orders of non-hospitalization. And a couple of years ago, people who are defendants in criminal cases who are heavier than found incompetent to stand trial or not guilty by reason of consent. And the next step of the process there is what's called the hospitalization. And court is determining whether hospitalization or involuntary psychiatric treatment is going to be required. What I always like to start with, and I think it's particularly relevant here, is that the best thing that the legislature could do to address all the problems of the mental health system is to substantially and sustainably increase the resources devoted to the community mental health system. Inadequacy, at any given point, there is probably 1,000 job vacancies in the community system who all the designated agencies. And inadequacy of the system makes it unable to respond to crises, and probably more importantly, it makes it unable to avoid people going into crisis. And this leads to all kinds of problems, homelessness, but also criminal acts that could have been avoided if we had the immune system. However, this bill is a solution in search of a problem. It is not something that is necessary to address an actual problem confronted by our state. For years, we've been told by advocates for this type of legislation that the forensic population, people who've been charged with crimes and be found competent or not guilty by use of insanity, is so different from the rest of the psychiatric population that in the rest of people in the mental health system, that they need to be segregated into some other type of facility. And my observation from interacting with people that I've been representing in different cases and criminal cases is that this is just not approved. There's no reason. Typically, the people who are found not guilty by using insanity or incompetent to stand trial have the same psychopathologies, the same things that bring them to this state as anyone else in the system. And there's no reason to think that their needs are different in the educational system. What we see now is that there are people in psychiatric hospitals who got there by reason of being found incompetent to stand trial or not guilty by reason of insanity. They're receiving the same treatment from the same body as in the system. And right now, every person who is involuntarily detained in one of our psychiatric hospitals is there to themselves either in court or they're waiting to hear with some mental health professional has evaluated and concluded that they need to be hospitalized for their own protection or for the protection of the public. And that's true whether they're there because they're charged with a crime or whether they're there's been some other incident that someone could believe that they're in danger with someone else. Similarly, everyone is on an order of non-hospitalization, which is the month's version of outpatient treatment, where someone's ordered to receive involuntary mental health treatment, but not required to go to the hospital. Everyone is on order of non-hospitalization because they have drugs. There's the determination that they could be on an order of non-hospitalization, they can be safe without unreasonable danger to themselves or to the public. That's on an outpatient basis. Another thing that, well, I'll get to that point here. This bill proposes to detain certain people, and it's hard to know even how many people it think it's going to be. But opposed to saying that they certain people in the most restricted and most expensive setting possible. With no show on. And so the question is, should we really be creating a new expensive, high security facility when people's needs are the advantage? The bill, as I've read it, raises serious constitutional difficulties and overturns a long-standing Vermont Supreme Court precedent. And because of that, this is likely to result in court challenges on a number of respects. I'll just mention a couple of things. First, the goal, in fact, as far as the 1970s, the U.S. Supreme Court in case the O'Connor versus Robinson and Addison versus Texas held that as a matter of constitutional law, someone can't be detained without a showing that someone that has mental illness cannot involuntarily hospitalized without a showing by clear and convincing evidence that they pose a danger to themselves or others. This bill is not important and show. The second, due process and requires that whenever the government is going to deprive someone of their liberty, and it's very clear that involuntary commitment is a deprivation of liberty. The government has the obligation to prove that it's justified by showing the danger. This bill would shift that burden from the government showing they need to require the patient to prove by clear and convincing evidence that they're not intentional. So that is a clear constitutional violation right there. Vermont Supreme Court has held that due process requires that once a person is committed, they're entitled to have periodic review of their detention initiated by the government, and we establish that in the case of MHK back in the 1980s, and this bill either puts the burden on the defendant to request a review of their detention, or instead the alternative is what I would say is an unreasonably long, probably unconstitutionally long interval of 5 years for the automatic review. And finally, this bill is just not necessary. What we see now is sometimes people are admitted to the hospital for treatment, for psychiatric treatment, after they found incompetent to stand trial. And when they're there, they get the standard treatment for psychiatric patients based on their condition. And even without the specific mandate, which law doesn't have, even without a specific mandate to do what can be done to make them competent, we have seen numerous cases in which the application of the standard psychiatric treatment has resulted in the person restored to competence and maybe being able to stand trial for their offense or enter a plea sentence for their offense. So, summary, this bill is significant and serious constitutional concerns. It needlessly deprives people of their liberty and goals that it would achieve can be met without taking this action. So we oppose this bill. And I know you're at the stage where you're considering how much time you want to devote to it. I think this is very, very complicated. It's going to take a lot of time to work through all the issues. And in the end, I think the concerns are really not surmountable. Okay.
Thank you. Just a few questions. Regarding competency restoration, and that's the piece that at the moment I'm most interested in. And I'm trying to figure out what, how to balance this in situations where somebody is found not competent to stand trial. And then their case just ends up existing in this, in the ether, essentially, and there's really no resolution except, every several months they come back, they say, yeah, it's still not competent to stand trial, and then it just becomes inactive. And so, can you expand a bit more on your thoughts regarding section 1 and competency restoration? And I know you mentioned you just wanted to provide a general overview, and this is a bill and I think a lot of time, but do you have any more specific thoughts about competency restoration as it relates to this?
Well, yeah, there are a couple of observations. One is that the great majority of cases in which someone's found incompetent to stand trial are misdemeanors and minor offenses, and often part of the resolution of those cases is either the cases found brought on inactive status, the judiciary, or just dismissed by the state's attorney. And I'm glad that section 2 got some clarity to that. But as for section 1, I haven't seen an indication of how someone would be restored to competency other than by the treatment they see in the hospital anyway. And for someone who's charged with a serious offense, I certainly represented many people whose underlying charges were that was some form of homicide. I've seen those people who have been treated and restored to competency within the normal course of our mental health system, or treated brought to the point where they no longer pose a danger to themselves or others, and then are able to be out of confinement and brought to treated when the community really no longer pose a course of condition in the brain.
That's all I have for quite a while. Any input or comment?
Okay. Thanks very much. I'll be
If you have
following this as this comes up.
I'm sorry.
I'll be following this.
Okay, great. And I was going to say, if you have as we progress along, if you have more specific testimony on different provisions of section and so on that you want to testify on, just let us know.
Great.
Thank you.
Thanks a lot.
Jeff, and for what are the
Have anybody else? Sure. For 193. We'll put back. All right. So committee, we can go on. I believe we're going to be coming back at 10 a.m. Is it for 208? Quick update on red. Correct. Okay, so we'll be back at 10 a.m. Some testimony from Rick regarding S208. Then shortly after that, we will be addressing the Supreme Court nominations. So needs to be back right around that.
Right around town or